A judicial confirmation hearing is supposed to be a rigorous job interview for one of the most powerful positions in the country. But what happens when a nominee, under oath, can't or won't answer a direct question about the fundamental laws they would be expected to interpret? This isn't just political theater. It's a critical moment that reveals a deep and consequential battle over the very nature of government power. The question is, are we witnessing a calculated political strategy or a concerning lack of preparation? Let's look at the key exchange that reveals everything.
I'm not going to ask you your opinion on precedent, and I'm not going to really ask you about past cases. I just want to talk to you a little bit. Judge Lee, tell me what your understanding is currently of the Chevron doctrine.
Thank you, Senator Kennedy, for that question. My understanding currently of the Chevron doctrine is that the doctrine is a general matter that courts should give deference to agency factual determinations to the extent that the agency has been empowered by Congress to regulate certain areas.
How much deference have the appellate court said you should give? Explain what you mean by giving them. I know what deference is, but do you give them a lot of deference? What if they come up with an interpretation that is patently absurd? Do you have to defer to that?
Thank you, Senator Kennedy. Senator Kennedy, I know that the issue of the Chevron doctrine and the deference that courts should afford to agencies is an issue that is currently hotly contested in various litigation. And as a sitting district judge and as a nominee for the Seventh Circuit, I feel that it would be imprudent to provide my advisory views with regard to that issue.
Look, I agree with you, Judge. I'm not asking your advisory view. I'm asking you to tell me what the law is. What's the current state of the law? I agree with you. Under Chevron, the courts have said Congress has delegated this expertise to the regulatory agencies. You're supposed to defer to them. What is the current state about how much deference and when, if ever, you don't defer to them? That's all I'm asking.
Again, Senator Kennedy, given how hotly contested that issue is, I feel that at this point in time, as a sitting district judge and as a nominee to the Seventh Circuit, that
Judge, let me interrupt you. You're
Yes.
telling me you can't tell me what the state of you won't tell me what the state of the law is on the Chevron doctrine? I'm not asking your opinion on it. I'm just telling me what's the latest guide. Let me rephrase it. What is the latest guidance that the United States Supreme Court has given us on the Chevron doctrine? I mean, it's pretty important stuff.
Yes, Senator. The Chevron doctrine, as I stated, was that the court should give deference to agency determinations in matters that specifically deal with their particular realm that
Right.
Congress has
We
delegated.
went over that. How much deference? When do you not defer to the agencies?
As I recall, Senator, the degree of deference that a court should afford agencies really deals with the process that the agency went through in making its determination, as well as to the exact and precise nature of that determination.
Yeah, I don't agree with that, Judge, but that's okay. I'm surprised you haven't seen the issue of Chevron before. You're going to see it on the Court of Appeals. It's pretty important stuff. Judge Mendoza, one question. I've only got a little bit of time left. Look, you wrote a law review article back in law school, and I don't hold that against you. You know, when I was in law school, we all did things when we were young that, you know, it seemed like a good idea at the time, okay? But you made, if I got this wrong, tell me. But you made one statement. I was looking at your piece. I think this came from your article. I'm gonna read you the quote, and I just didn't understand it. Here's your quote. One must understand race as a socially constructed phenomenon that has historically served to subordinate racial minority groups while maintaining white supremacy. I've never thought of race as a socially constructed phenomenon. Tell me what you meant by that statement.
Thank you, Senator, for that question. And I think you're referring to that article that I wrote 26 years ago,
Yeah.
when I was a law student. And of course, since that time, Senator, I've became an attorney. I swore an oath. At that point, I became a judge.
No, I'm not trying to trip you up. I'm just trying to understand what you meant by it. When I first read it, I said, well, you know, that's an interesting construct. I just don't understand it.
And Senator, as I sit here now, I can't recall that specific quote, but what I can tell you is when I deal with the issue of race in my court, it's usually in a claim. And what I do in those claims is I apply the precedent on the matter. I look at the facts and I make those determinations.
Let's break down what just happened. Senator Kennedy's strategy here is deceptively simple. He isn't asking Judge Lee for her personal opinion on a controversial social issue. He is asking her to explain the Chevron Doctrine, a foundational principle of administrative law for the last 4 decades. This is the equivalent of asking a pilot about the principles of lift. His goal is to test her basic competency and her judicial philosophy. Can she clearly articulate the current state of the law she would be sworn to apply? Notice her response. Instead of explaining the well-established 2-step framework of Chevron, she deflects. She describes the doctrine in the most general terms, saying, courts give deference to agency factual determinations. This is a vague and partially incorrect description. She then repeatedly falls back on the idea that the issue is hotly contested. While it's true that the future of Chevron is being debated, Senator Kennedy rightly points out he is not asking for her opinion on that debate. He is asking, what is the law right now? Her refusal to answer that direct question is the central issue. It suggests one of 2 things. Either she doesn't have a firm grasp on a core legal doctrine she would encounter on the appellate court, or she is so afraid of saying something that could be used against her that she is deliberately evading a straightforward legal question. To understand why this matters, you need to know what the Chevron Doctrine Island. Put simply, it's a rule that tells judges how to handle cases where a government agency, like the Environmental Protection Agency or the FDA, has interpreted a law that Congress wrote. If the law is crystal clear, the court enforces the law. But if the law is ambiguous, the Chevron Doctrine says that courts should defer to the agency's reasonable interpretation. The logic is that Congress has delegated power to these agencies because they have specialized expertise in complex areas like science, finance, or telecommunications. This doctrine is the bedrock of the modern regulatory state. It underpins countless rules related to clean air, food safety, and financial markets. The hotly contested part she refers to is a major push from conservatives to overturn Chevron, arguing it gives unelected bureaucrats too much power. By pressing her on this, the senator is probing her stance on this monumental legal fight. The 2 key themes that emerge from this exchange are judicial competence and judicial candor. First, her inability to articulate the specifics of the doctrine raises questions about her readiness for a seat on a powerful federal appellate court. Second, by refusing to state the current law because it's being litigated, she creates a troubling precedent. If nominees can refuse to discuss any legal principle that might one day come before a court, the entire confirmation process becomes meaningless. This isn't just a theoretical legal debate happening in a vacuum. The question of how much power agencies have impacts your daily life in countless ways. Think about the rules that ensure the medicine you take is safe, the standards that dictate how much pollution is allowed in your air and water, or the regulations that protect your bank deposits. These are all created by federal agencies operating under authority granted by Congress. The Chevron Doctrine is what has historically given these agencies the flexibility to apply their expertise to implement laws and adapt to new challenges, whether it's a new technology or a public health crisis. To put it in another context, imagine a city council passes a law saying all new buildings must be safe. What does safe mean? Does it refer to fire codes, earthquake resistance, or electrical standards? An expert agency, like the Department of Buildings, would create specific rules to define safe. Under Chevron, a court would defer to the agency's reasonable definition. Without Chevron, a judge with no engineering expertise could decide to impose their own different definition of safe, potentially overriding the judgment of experts and creating uncertainty for everyone. The debate highlighted in this hearing is fundamentally about who gets to fill in those details, expert agencies or generalist judges. So, what are the key takeaways from all of this? First, this exchange demonstrates that confirmation hearings can be a powerful tool for testing a nominee's fundamental legal knowledge, not just their political views. Second, the nominee's evasiveness on the Chevron doctrine reveals a critical fault line in modern American law, the intense struggle over the power and legitimacy of government agencies. Finally, it shows how an abstract legal doctrine, debated in a hearing room, has profound, real-world consequences for the regulations that shape our health, safety, and economy. Is it acceptable for a judicial nominee to refuse to explain current, established law, or is it simply a savvy political move to avoid a confirmation battle? What do you think? Let us know in the comments below. And if you found this analysis helpful, be sure to like, subscribe, and share this video.